Hey out there, legal warriors. What are the steps to a DUI case? A first offense DUI, a second offense DUI, they're all pretty similar. So if you're interested in what to do if you're faced with a DUI, or if you have a DUI charge right now, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I've been defending people charged with crimes for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. A DUI case. What are the steps to handling a DUI case? If you're a driver, if you're somebody who's charged with that, or if you know somebody who has, or you're just wondering what's going to happen in the future should this happen to me. Well, how a DUI case normally starts, as you might imagine, is a police officer pulls over a vehicle or responds to a scene of an accident or some type of other incident, and then they either arrest somebody for DUI or they issue them a citation for DUI. There's usually a breath test involved. There might be field sobriety tests. A car might get towed. All these things could happen. And so if you've had police contact, the first thing you need to do is pay attention and see if you have a court date, because you don't want to miss any court dates. If you're out of custody, the officer might have given you a court date, or they might have said you'll receive one in the mail. So how does that work? Why is there a difference? Well, city police officers typically will sign their own complaint for DUI and go ahead and file it into a court, and they might say, hey, you have court the next day, because there's certain rules that have to happen for DUI charges. If it's a state patrol officer or a county sheriff, typically speaking here in Washington State, they aren't allowed to file their own complaint in the court. They've got to send a police report to a prosecutor and let them decide what they're going to charge and when. So pay attention and see if you have a court date, because it could be the very next court day. So on a Saturday, that would be a Monday, right? And if you're not sure, get a hold of an attorney, because an experienced attorney is going to have a very good idea of what is happening in your case just from experience, at least if they've done it for a while. So that's the first thing. Look for a court date. I think the second step that you want to worry about is paying attention to any paperwork the officer gave you, because you may have to request a Department of Licensing hearing. Now in Washington State, when we drive on the roads of Washington State, we've impliedly consented, it's called the implied consent law, to a test of our breath or blood to see if we're legally able to drive in relation to alcohol or drug usage. So if an officer has reasonable grounds to ask us for a breath or blood test, we can refuse it, and then there's a licensing consequence, or we can take it, and there's a licensing consequence if we have a certain result. For adults, that's 0.08 or higher for alcohol, or 5 nanograms per milliliter of marijuana on a blood draw, and that takes a while to come back. But in most cases, you're going to have some forms if you took a breath test, or even if you refused a breath test. If you took a breath test, you're going to have a breath test ticket. It's going to have your numbers on it and say what it is that the result was. If all the numbers that are breath tests are higher than 0.08, then you're likely going to have a licensing hearing you need to worry about. For minors, it's 0.02. So also take a look in your paperwork and see if you have a driver's request for hearing form. And you're supposed to have one of those if the officer is taking licensing action against you by sending something to the Department of Licensing. But in my practice, I would say 25% of the time, when a driver should have one of those, they don't. Just paperwork happens. Maybe someone loses it getting released from the jail, the officer makes a mistake, or it just gets misplaced. So the most important thing is you only have 7 days from the date of the incident to request a licensing hearing with the Department of Licensing to contest any possible suspension of your license. And that means that you need to go ahead and mail in a form requesting a hearing within 7 days of the event. Nowadays, in 2022, there's a $375 fee for that hearing, or you need to do it online with your Licensing Express account at www.dol.wa And again, it's the same fee for that. We like to suggest mailing it in, make sure it's postmarked within 7 days, but everybody has a different opinion about what is best for them. And the sad part about this is that where people make mistakes is sometimes somebody doesn't realize their license is going to be suspended. They didn't get the form, and later they'll get a notice in the mail from Department of Licensing, surprise, you're suspended for 90 days, or if you refuse, you're suspended for a year, or if it's your second offense, you might be suspended for 2 years, and hey, too late to request a hearing, so too bad. So if you do request a hearing, then it's going to put any license suspension on hold. So there's a chance for you or your attorneys to fight that suspension or even build a case on the criminal side through the process of fighting the suspension. And so that's a much longer topic, and my channel has some other videos on Department of Licensing hearings and what happens at the Department of Licensing hearing. But again, that's step 2. 1, figure out if you have a court date. I don't want you missing one and getting a warrant. And step 2 is Department of Licensing. I don't want you to miss a deadline and lose that really important opportunity to be able to fight a license suspension and build a defense in your case. So what's the third step in a DUI type case? Well, I think the third step is contacting an attorney. You need to contact an attorney right away, because in DUI, like many different types of crimes, there are things you can do today to improve your chances in the future. What might that be? Well, you might be able to do an alcohol evaluation in your case early to try to make a good impression on the prosecutor and the court. An alcohol evaluation is going to a professional agency, paying them some money, and then answering some questions about alcohol and drug usage, past history, stuff like that. There's also going to be a UA, a urinalysis test, to see if there's anything in your system, and then that agency is going to make a recommendation. So that's something you can do early, but you'd want to talk to an attorney to see if does that make sense in your case, and if so, where should you go to get that evaluation done? Because in my opinion, evaluators are financially motivated to recommend more treatment because potentially they might get more payment if there's more treatment recommended. And so that's just my opinion from doing this for 30 years. So there's certain places that are a little more likely to be maybe more fair about alcohol or drug usage, at least in my opinion. There's some places that are a little more heavy on the treatment. Neither is right or wrong, just that I think that one might be preferable for most people than another. So you want to talk to an attorney about that. You could also do a DUI victims panel. You could do that early. It's usually a 2-hour class. It's inexpensive, 1.5 to 2 hours, and it's listening to people who have had their life affected by a DUI driver. It could be an actual victim who suffered an injury. It could be a law enforcement officer talking about what they've seen, but it's meant to make an impression on us so we can understand that it's serious. And if we do these things early, then there's going to be something that your attorney can use. So we might as well do what we can, right? We might as well do what we can to improve our position and help our lives from this unfortunate event. Also, by talking to an attorney early and getting one involved early, you're going to feel better. You're going to feel better knowing you've got an attorney or a team of attorneys working on your behalf and telling you what to do and picking up your spirits and challenging all the nightmarish things that might be going on in our head, how we've ruined our lives. And in my experience, at least the first offense DUI is inconvenient. It's not typically a life ruiner. Second offense gets a lot worse. Third offense gets a lot worse, but it's oftentimes can be handled if we do things correctly. So that's number 3, is talk to an attorney. The fourth step is going to court. Going to court. You're not typically going to go get arrested and bring you to court unless you've missed a court date. That's why you want to be following the first steps. But you're going to get a summons to appear in court for an arraignment. And an arraignment is where a court's going to tell you the nature of the charges. You're charged with DUI, and they're going to ask you to enter a plea. That's not guilty. And then they're going to set some conditions on you and set some court dates. And the conditions are the things we want to worry about. If we have a prior offense, they're going to make us put an ignition interlock in our car. If we have a really bad offense, they might do that. They might make us wear a scram bracelet, what I call the Lindsay Lohan bracelet, where you have to, it monitors whether you have alcohol or not, and it's on you 24 hours a day. It's really a pain in the butt and costs around $400 a month. and they can order you not to drink and drive, stuff like that. But typically it's standard conditions: don't drink and drive, don't commit any crimes, come back to court. So that's the arraignment. That's the first step in the criminal process. The second step in the criminal process are pretrial hearings, and there's usually many parts of this step, many pretrial hearings. And that's where your attorney and the prosecutor are going to sort of meet in court to acknowledge a case exists and move it towards resolution. And somewhere in there, that Department of Licensing hearing may happen, and your attorney may gain some information to help negotiate your case. Hopefully that attorney is also going to take your alcohol evaluation and how great you've done in any type of treatment recommended, the minimum being alcohol drug information school, to try to help negotiate your case. Hopefully in those pretrial hearings, your attorney is also going to look into the breath test device. Was it working properly? Was it a legal stop? Are there any videos that the law enforcement officer has that where we can either see or hear what happened? Were the field sobriety tests properly instructed? Were you wearing too high of heels to be able to do the field sobriety test? Was it cold and you were freezing and therefore that wasn't fair? Or there was traffic zooming down the side of the road, so that wasn't fair. So these things will all be worked out over time, and hopefully then we move on to the final stage of DUI defense, which is some type of resolution. Hopefully you're looking at a negotiated resolution and not a trial where you can try to be done with this and put it behind you. And what are some possible outcomes of a negotiated resolution? Well, there could be pleading guilty to a DUI. Let's hope that doesn't happen. There's mandatory minimums, including jail time, and we've got some specific videos on that here on our channel, different for first or second offense DUIs. Or there could be reductions to lesser charges: reckless driving, negligent driving first degree. Those are lesser charges that don't carry mandatory jail. The reckless driving has a licensing consequence. Typically, the negligent driving first degree does not. But at that point, at any type of resolution, you as a defendant are going to have an opportunity to say something. You won't be required to. Hopefully, your attorney will help you figure out what might work for you based upon what's true for you, what matters to you, and what's going to help your case. After that, we might have a period of probation. Sometimes we're going to have a probation officer to report to. If we've already done everything ahead of time and there's no active conditions, like there's no treatment to monitor, things like that, then oftentimes we're going to have an inactive probation, and you won't even know that there's a court monitoring your future behavior. So typically we're going to have some fines. If we suffer a suspension, we're going to get our license back at some point. We might have to maintain a certain type of insurance for a period of time. But for the most part, it's survivable, and those are the steps of defending a DUI case in Washington State, or actually just going through one as a defendant. So I hope you found this helpful. Hopefully I've sort of cleared up some mystery if this is something you've not been through before. And if you find this useful, please like and please subscribe. More people will get this type of help that they need, because more people will see this. And finally, if you have this type of situation, feel free to reach out to my firm. My name is Lance Fryrear. I've got a law firm in Linwood, Washington. We've been defending DUIs and other types of crimes all throughout Washington State for more than 20 years. If you give us a call, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.